Good morning. We are calling to order this Rules Committee hearing for Wednesday, November 29th. And I'll note for the record that there is a quorum present. Thank you all for coming in during the interim. It's good to see everyone. The first order of business for today is approval of the minutes from Wednesday, June 7th. Leader Damath, would you care to move the minutes?
So moved, Mr. Chair.
Any discussion? Seeing none, all those in favor of approval of the minutes, please say aye. Aye. Opposed? The minutes are adopted. The first order of business for today is approving the LCC legislative plan for employee benefits. If Ms. Knight could come forward, I will allow her to present on the LCC plan for our approval. Good to see you, Ms. Knight.
Mr. Chair and members, you have the stricken and underlined LCC book for employee benefits before you. This is a policy book that the three entities, the House, the Senate, and the LCC nonpartisan staff put together. And the LCC has already adopted the changes that they have statutory authority over, and what you see before you are the changes that the Rules Committee has to approve. In the changes, for policy changes, you're going to see on page 5, it is making it clear that and expanding the use of the lactation room to include nursing children. That is something that the House did allow, and we just put it in the book so that it was clear. We also, on page 6, have been encouraging staff to register with Everbridge to receive capital security emergency messages. Then on page 8, it puts in writing so that staff know that any telework policy must be developed and approved by the appointing authority. That just because one body has a particular telework policy does not mean that automatically extends to the other body.
I'm confused. What are we looking at?
Also, page 9, it adds a legislative break day. And that is something that this body has done, I want to say for 26 out of 28 of my years here. And this just memorializes it. What you will note is that it will be the Friday before the conclusion of the legislative break. However, when we have a split break or multiple breaks, it will still then fall to leadership to designate which day that is going to be. So that will be the case this year, that leadership will decide which day that is going to be. On page 26, this allows the Senate and the LCC, should they choose, to permit employees to donate vacation time to executive and judicial branch employees. The Senate and the LCC are on the state payroll system, and so they have the ability to do that. The House, with us doing our own payroll system and producing our own payroll, we do not have that ability to do that. Then page 26, this is regards to donated time. It clarifies that the maximum that any employee can receive in 1 year is 1,044 hours of donated time. We also want to make it clear that if someone used donated time, received it 1 year, and then 5 years later had a tragic event and was in need of it again, they would be eligible for another 1,044 hours. So it's just in 1 calendar year. On page 28, there are actually two pieces that pertain to election judge and voting leave. The first, it clarifies that staff who work less than full-time do not get voting leave on a day that they weren't scheduled to work. So you have to be scheduled to work if you want to claim voting leave for that day.
Ms. Knight, I'll just mention that I think the page numbers we have are, I think, off by one.
Sorry about
From what
that.
you're saying, just for members who are following along, I think we're one page ahead of the numbers you're citing. So please continue.
The second piece of that is that it prorates time in excess of 32 hours per calendar year for employees serving as an election judge. And what that means is if someone is serving as an election judge, they can get 32 hours and not have to give the House the money that they receive for being an election judge. However, anything in excess of that, the House would prorate. And the final one is a clarification that indicates that the House, Senate, and LCC are considered separate entities for the purpose of our deferred compensation plan. The House has a matching program as well as a conversion program, and we want to make it clear that we're each separate entities.
Right. Questions from members? Representative Robbins.
Thank you, Mr. Chair. Thank you, Ms. Knight. I have several questions. So first, on page 8 in our packet, looking at the telework benefit, it doesn't specify that the telework has to be in Minnesota or that someone couldn't approve allowing an employee to work out of state for an extended period. Could you, so if someone wanted to, say, work in Florida for the month of January, is that something that would be able to be approved?
Ms. Knight.
Mr. Chair and members, we have had people that have, during COVID, who have worked out of state when they have had a family emergency, but extended leaves, or extended remote work, we have not allowed, other than the contiguous, we have people that live in Wisconsin.
Right.
For example. But for someone who would want to move, let's say, to Florida, we would have to, for 6 months, we would have to collect taxes. We would also have to secure work comp. So we have had people ask, and we have said no.
Representative Robbins.
Thank you, Mr. Chair. Thank you. So definitely that's not been the position of the House, but there's nothing in this that would prevent someone from approving it.
Ms. Knight.
Mr. Chair and members, any alternate work would have to come through my office in addition to the caucus director. So Andrew would have to approve it in the case of the Republican caucus, and I would have to approve it. But the Senate, the LCC could approve that, but that has not been the position of the House.
Great. Thank you.
Representative Robbins.
I just have to kind of grab through my notes here. On the election judge leave, if you don't mind, on page 27 in our packet. I just wondered, so they can do 32 hours and they're still being paid salary in addition to what they're being paid as a judge? Like, it doesn't affect, like, it's not unpaid time that they take?
Ms. Knight.
Mr. Chair and members, yes, that is correct.
Thank you.
Representative Robbins.
And can I ask a couple more, Mr. Chair?
For sure.
Okay, thank you. On page 25 on our packet, the leave donation, I just was unaware of this, so I'm just wondering, how common is it And then secondly, you referenced, someone could get the 1,044 hours every 5 years as an example, but it looks like someone could be donated 1,044 hours every single year for a qualifying event. Is that accurate?
Ms. Knight.
Mr. Chair and members, it is correct. So the leave donation, in order to qualify for leave donation, it's a rare occasion that we actually have someone. So they have to be off for 6 continuous weeks, and it's for a medical condition, and they have to exhaust all of their own sick time and their vacation time. And it's actually a policy that is approved by this body at the beginning of the year. And if someone had a situation where they had 2 tragic events back to back, yes, they could receive up to 1,044 hours of donated time. And that is time that employees of the house would donate their vacation time to that individual to be used as sick time.
Great.
Representative Robbins.
Thank you. And it doesn't specify in here that it's only for use of sick time, but I'm assuming that's somewhere else specified.
Sounds like that wasn't a policy we adopted earlier. Ms. Knight.
Mr. Chair, members, yes.
Perfect.
Representative Robbins, further
I'm
questions?
almost done.
Yep. Nope.
Oh, on page 28, where it talks about additional leaves of absences, I just wondered if you could explain it. So in addition to sick leave, there's quarantine leave, domestic abuse leave, harassment leave, witness leave. So is there a specific time for each of those additional leaves? Or is it up to the employer to just approve it? How will that work?
Ms. Knight.
Mr. Chair and members, we refer back to the statute. For those in my time, I think I've only had one of those utilized. So I'm not specific on the exact time for each of those, but that's why we reference the statute.
Okay, thank you.
Representative Robbins.
And let me just double check here. Oh, I can't remember what page it's on. It was towards the beginning, but I did want to just ask for clarification on the changes where you include gender identity. Is that tied to a definition anywhere in statute? It doesn't reference anything, so I wondered, it's on page 4 in our packet and 3 in our packet. And I know in statute this year we did include gender identity in the human rights statute, but I don't know if it's tied to any definition, but it's fairly broad. So I just wondered if there is a definition you're using.
Ms. Knight, and I'll also ask if that's a change we're making today or if that's in the underlying policy.
Mr. Chair and members, the gender identity is actually part of the House's harassment discrimination policy. So that's the language we're updating it here.
Right. So,
Representative Robbins.
thank you, Mr. Chair. So is it defined in the discrimination policy? Like, where is the definition of this?
Ms. Knight.
Mr. Chair, members, yes, it is. It's defined in there.
Representative Robbins.
Thank you, Mr. Chair. So could you give me the definition?
Mr. Chair and
Ms. Knight.
members, I can get you a copy of the policy. I just don't have it with me.
Perfect. Thank you, Mr. Chair. Thank you, Ms. Knight. Appreciate all your work.
Thank you, Representative Robbins. Representative Rarick.
You got it, Chair. Thank you. I know, I should put it up high.
Got a new name badge and everything. Congratulations.
I do. A whole new name and everything that comes with it. Mr. Chair, just a procedural question.
Sure.
I know that when Ms. Knight started the presentation, she said that the change items would be underlined and stricken through, and we must have a copy that was predating that or something, because our copy doesn't have that. That's at our spots, and I'm just wondering in the future if we could have that. It's just hard to flip through a very long 71-page document without having underlined and stricken through to,
No, that's fair. I think it
Compare.
was in the email that was sent out, and that must have been part of the discrepancy for the page numbers, I bet. But it was sent ahead of time if you wanted to pull it up. And I'll note that for future printouts, we'll try to make it aligned.
I appreciate that, Mr. Chair. And I would, but the cell service down here is sometimes kind of sketchy, so a lot of us don't even bring our cells down here because they don't work, but.
Yep.
And I didn't bring a laptop, but anyway, if you would just do that, that'd be great, thank you.
For sure, a fair comment. Any other questions? Okay, seeing none, I move the adoption of the 2024-2025 LCC Legislative Plan for Employee Benefits. All in favor, please say aye. Aye. Opposed? The plan for employee benefits is adopted. Ms. Knight, if you could stay where you are. Next item is the 2023 P3J Policy on Compensatory Time, Non-Exempt Overtime, and Time Card Policy. If you could please present the 2023 P3J.
Mr. Chair and members, there are just a few changes to this policy. On page 1, lines 27, 28, this body made a change, a temporary change last year to temporarily move the comp time accrual max to 300 hours. What we are doing here is we are making that a permanent change in the policy. And we are indicating that it is effective November 1 of 2023, which is the beginning of our comp time accrual period.
Questions for Ms. Knight? I don't see any questions. I then will move the adoption of 2023 P3J, the policy on compensatory time, non-exempt overtime, and time card policy. All those in favor, please say aye. Aye. Opposed? The policy is adopted. We have one last item of business, and for that, if we could have Barb Julich come forward. This is March 31st, 2023, legal invoice, RE legislative recall petitions. Ms. Julich, if you could explain the expenses.
Yeah, Mr. Chair, members, Barb Julich, Chief Financial Officer for the House. Before you, you have a legal bill for cost incurred by 2 members of the House relating to a recall petition. It is the policy of the House that any legal cost incurred by an individual member as part of being a member be reviewed and approved by the Rules Committee. So therefore, this is before you today. The costs were incurred by member Wolgamott and Keeler relating to a recall petition that was dismissed due to the failure by the petitioner to allege any specific facts that the person would be would meet the grounds for a recall. So the case was dismissed by the courts, and this was the cost incurred by those 2 members that is before you. Again, our policy does allow for any reasonable costs for an individual member to be reviewed by this committee.
Thank you, Ms. Julich. And so these allegations for the recall were for their actions in an official capacity for taking votes, I
Taking
believe.
votes. Yes,
And that's
Mr.
what the
Chair.
court noted, that a vote is not a ground for a recall. Is that correct?
That is correct, Mr.
Okay.
Chair.
Any discussion or questions to the invoice? Representative Rarick.
Thank you, Mr. Chair, I appreciate that. Ms. Julich, I'm just, I've been here 11 years, I haven't been here forever, but just wondering, I don't remember any recall actions taken against members in the 11 years I've been here. Has this happened in the time that you've been here? You've been here a bit longer than I have.
Ms. Julich.
Mr. Chair, members, I've been here 5 years, and maybe seems like longer.
Yes, it does.
No, in my tenure here, Mr. Chair and members, we have not seen a recall petition legal invoice for members or in your past 11 years either. As I look back, I have not seen a payment for this type of activity that I could find.
Further questions? Representative Merrick?
Thank you, Mr. Chair. I'm sorry, there's a fan above my head. So you did say the last 11 years you look back and you hadn't seen anything?
Ms. Jewett?
Mr. Chairman, correct. I have not seen, I don't know if there has been a recall petition in the last 11 years. I just know we have not paid for any legal cost related to them.
Representative Merrick?
Thank you, Mr. Chair. So if the court found that there was cause and moved forward, at what point does the legislature continue to pay the legal bills?
I can answer that.
Oh,
That would be-
thank you, Mr. Chair.
That would be a choice for the committee. It's the committee's decision whether to pay a legal bill or not. So we, as you noted, this is not a situation we've faced very often, so I don't think there's a lot of precedence to go on. But in our view, given that this was a petition based on their official work and was dismissed, it felt appropriate for this to be a cost for the House to bear. Representative Merrick?
Thank you. Yeah, I'm just processing that answer through. So, Mr. Chair, if we, and I've been here a little bit longer than you have, but if we don't, is this precedent setting? I guess to be the next question, maybe our nonpartisan staff could let us know, is this the first time? Are we setting precedents? I think that's important to understand. If this has not been done, at least in the last 11 years, I don't know if it's been done before that, but are we setting a precedent here?
Well, I'll give my response, and I'll happily let non-partisan staff respond. I think certainly each body gets to make their own decisions about expenses and what they approve or not approve. If this is setting precedent, I don't think it's a bad one, which is that if a member is sued in their official capacity and the case is dismissed, that the cost should not have to be borne by that member. Mr. McCormick?
Mr. Chair, members, this is the first time that we've, in our records, that we've paid for this kind of a expense for members. And we're paying for it under our current policy, House Policy 2023 P5, which was adopted at the start of the 2023 legislative session. And that policy doesn't automatically pay for anything. It empowers the committee to decide whether to pay. So the precedent today is that, and it specifically states, based on the facts and circumstances in a particular case. So the precedent that we're saying today applies to the facts and circumstances in these cases, and we would and should examine the facts and circumstances in any future case and make an independent decision.
Further questions? Representative Merrick?
Thank you, Mr. Chair. Okay, so if I understand the logic correctly, we are paying these bills because an individual or group, I don't know who was the plaintiff in this, filed a petition with the court to recall two sitting members of the legislature, Representatives Keeler and Wolgamont, because of votes they took.
Correct.
So somebody took umbrage with votes that were taken. So it's on that basis, because that's a frivolous lawsuit, because that's what we're elected to do is to vote. It was on that basis, that's why we're paying the bills, because it was found by the court as to be frivolous and literally opposed the reason that we're here.
That's correct. It was in their official capacity that the complaint was alleged that they took incorrect action, right? It was based on their votes, not based on any activity outside of the Capitol or any campaign activity. It was an official capacity, and the court very quickly dismissed it because the grounds are for malfeasance, and taking a vote is not it's not malfeasance. It's what we do, as you correctly stated. Representative Rare.
Yeah, thank you, Mr. Chair. Okay, so then as I see this, since we haven't done this in the past, this is an incredibly narrow circumstance, which two sitting members of the legislature took a vote, or 2 or 3 or 10 or however many it was, that a member of the public disagreed with and demanded that they be recalled. which is literally the reason why we're here in the legislature, is to vote.
Right.
And vote our conscience or vote what we feel is the will of the district.
Right.
So then what we're doing today would not be in effect, or we aren't setting precedents for something that would be considered malfeasance, which would be something unethical. They maybe they took a vote for something that they then benefited financially. That would be a conflict of interest, which we clearly are not allowed to do. So, so is it your view and the view of our vote today, if we vote to approve this, that it is only in that absolute narrow circumstance of something that was found frivolous essentially by the courts because it was an action that we are elected to do?
Yes, I think that's all that our vote today is saying, is that we are approving these two individual reimbursements, given that it was action they took in their official capacity and that the court found was frivolous and dismissed.
Okay, thank you.
Further questions? Okay. Thank you for the good clarifications, Representative Berg. I will then move pursuant to 2023 P5, Policy on Legal Fees, for the approval of payment of the March 31st, 2023 invoice for legal fees related to legislative recall petitions. All in favor, please say aye. Aye. Opposed? The motion is adopted. Representative Robbins, you had a question, I hear?
I do, Mr. Chair. I had a motion that I wanted to bring, and I know last time I didn't jump up soon enough, so I don't know if this is appropriate, but I just wanted to bring it forward.
Okay. I don't think we've seen it in advance, so I suspect that the motion may not we'll see what you have for us, but go ahead. What is your motion?
Okay, Robbins moves that the Committee on Rules and Legislative Administration hereby rescinds the R30-0 resolution, which gave primary tenant approval to the renovation of the State Office Building. The Chair of the Committee on Rules and Legislative Administration is instructed to inform the Governor and the Commissioner of Management and Budget that the House of Representatives as primary tenant no longer approves of this project. Members and Mr. Chair, as you know, I have been incredibly frustrated by the process that has led to us spending $500 million plus an additional $130 million or $230 million on interest, $730 million, members, on renovating this building. I don't disagree that there is need to update the HVAC system and technology and a few things, but the scope and scale of this project, which was approved in a lame duck Rules Committee session last year, that now has encumbered the taxpayers with $730 million for one building, is unconscionable. And when we all are seeing and hearing in our districts needs around the state that this money could instead be going towards, I cannot not continue to try to pull back on this project. It's not too late, members. We can, I tried, I sent a letter to the governor to not do the sale of the bonds. That didn't work. They did it anyway. There's still a chance we could pay back the bonds and just end this before it's too late. I don't want to get in the situation where we're like Southwest Light Rail and people say, well, we're too far into it, we have to finish. There will be, the NPR story that ran on this in September said they think $500 million is the floor, that there will be cost overruns and changes needed. Members, this project was begun before we realized that so many state office buildings are not fully occupied. Indeed, this building is not occupied unless we're in session. Otherwise, it's just 2 days a week. To spend $730 million on renovating this building that is open full-time 5 months a year, I can't fathom we are really going to go ahead with this, members. So I am just asking you to pull back. We can take a look at other options. I don't believe, I wasn't here, but I don't believe other options were fully vetted. My I was not made aware of it. Other members I've talked to weren't made aware of it. It was just like full steam ahead on this. I have asked for MMB to do an audit of all the available state properties. I don't have any response yet, but there are many other lower cost options that we could be doing that would support the work of the House, which we absolutely need to do, but that would not encumber taxpayers $730 million. The renovation of the Capitol was about $230 million a few years back. The full, brand-new Senate office building, which we all found appalling, at least I did before I was elected, was $90 million. How we are spending this much money for a House office building that is really only occupied fully 5 months of the year, I'm just begging you members, let's put a stop to this, let's revisit it. So that's what the resolution does. The way the statute is crafted is that the primary tenant had to approve it, which apparently happened last year in the Rules Committee when not even the full rules was here. So we, the primary tenant, can rescind that. And that is what I'm asking members to do.
So
And I would like a roll call.
Representative Robbins, your motion was not submitted before the hearing and was not a part of the agenda, so I'm finding your motion out of order.
I'd like to appeal the ruling of the chair
Representative
with a roll call.
Robbins appeals the ruling of the chair and requests a roll call. There will be a roll call, and the chair votes no.
Mr. Chair, could I ask a question?
Representative Robbins, we're in a roll call.
Well, I mean, what, did it have to be submitted ahead of time? My understanding is you don't have to submit a proposal ahead of
You
time.
can certainly vote against the ruling, but we're in a roll call at the moment. The clerk will take the roll. Leader Damath.
Mr. Chair, question?
We're in the middle of a roll call. We can have discussion after the roll call, but there was an appealing on the motion, and so we're moving to the roll. The clerk will take the roll.
Chair Long is no. Vice Chair Hollins is excused. Leader Damath?
Yes.
Leader Damath, yes. Representative Engen?
Yes.
Engen, yes. Representative Howard? No. Howard, no. Representative Hewitt?
No.
Hewitt, no. Representative Jordan?
No.
Jordan, no. Representative Lilly?
No.
Lilly, no. Representative Moeller?
No.
Representative Moeller, no. Representative Nash is excused. Representative Olson?
No.
No. Olson. Representative Pulowski is excused. Representative Rarick?
Yes.
Rarick, yes. Representative Robbins?
Yes.
Representative Torkelson?
Yes.
Torkelson, yes. And Wolgamott is excused as well. Mr. Chair, that is 5 ayes and 7 nays.
There being 5 ayes and 7 nays, the motion to appeal the ruling of the chair is not agreed to. Leader Damath.
Thank you, Mr. Chair. Could you please inform this committee when the pre-filing requirement is for the committee and when that was first noted?
So Leader Damath, we have an agenda that we set for the committee every meeting, and the agenda is posted publicly if members would like to have something on the agenda, and they need to inform the committee before the meeting.
Thank you, Mr. Chair. So the pre-filing requirement is when?
We do not have a pre-filing requirement for the rules committee.
So if there's no pre-filing requirement, then how was this out of order?
As I stated, if it was not notified to us in advance, then it's not going to be on the agenda. If it's not on the agenda, then it is not in order for the meeting.
Mr. Chair,
Representative Robbins.
I just find that outrageous. We are allowed to bring, we're full members of this committee, and there is no pre-filing requirement. So a
Representative Robbins.
very serious effort here to have a conversation about spending $730 million of taxpayer money is just ruled out of order because you don't like it?
Representative Robbins, if anything is in order at any time in a meeting, then the chair has no ability to control the meeting. So the ability has to be in the agenda and the ability to set it. Our business is completed for the day.
Mr.
With that,
Chair.
we are adjourned.